Florida?
The general process of a judicial foreclosure in Florida is that a summons is issued or papers are filed with the clerk of the court. The summons is issued and served on the homeowner, either by personal service or by publication. You don't want to have them serve you by publication generally because you don't know when the time starts and you don't know when that sale is going to take place. I've had people be on vacation for a month and they come back and their house has already been sold. So there cannot be a transfer of title without a public auction in a judicial state. The best thing to do when you get papers is at least talk to a good mortgage foreclosure defense lawyer. There are any number of organizations that have volunteer attorneys that will participate, give you a free consultation. The worst thing that you can do is either not see a lawyer or you see a lawyer who is not a good lawyer because he doesn't do that much in mortgage foreclosure defense. At least get a game plan and stick to the game plan. Once there's been a determination made, either a final judgment after trial or what's called a final summary judgment where the court looks at all the pleadings and says there's no legal defense, there's no legal reason why a sale shouldn't take place. It is generally about 30 days after the final judgment, and in many instances, clients are able to negotiate 60 to 90 days post-judgment before they have a sale. And after the sale is completed, the property owner has about 10 days after the sale to move out and not be forced out by a sheriff. They're not going to come in the middle of the night and change the locks or move you out summarily. It's not an eviction like a landlord-tenant case, but if you stay there long enough and you don't investigate your options and do a little planning, it could seem like that because you could be dispossessed by the sheriff. But it's not as overnight as in a landlord-tenant case.